appeal in the matter of Battersbee and Barts Health NHS Trust and another.
Yes, Mr Devereux.
May it please your lordships, may it please your ladyship, I appear once again with Mr Quintavarley and Professor George on behalf of the...
Just a moment. Could you just find someone else's notebook?
Sure.
Yes, as long as it's a notebook. I realise I've left my notebook in my room, and so do start. I will make notes, and we'll proceed accordingly.
Thank you. As your lordship and as your ladyship know, I appear with Mr Quintavarley and Professor George for the parents of Archie, those
yes.
parents being Holly Dance and Paul Battersbee, yes. who sit before you with a member of the family, Ella
yes.
Carter, and their solicitor, Mr Foster.
Yes.
For the trust is Mr Miller, Miss Patterson.
Yes.
And for Archie is Miss Watson,
yes.
Queen's Counsellor, Miss Stanley.
Yes.
My lords, as your lordships and your ladyship know, this is my application seeking permission to appeal the order of Mr Justice Hayden of the 15th of July.
Yes. And before we go further, I should explain that in accordance with the usual practice of the court, this hearing is being live streamed. And so, as you will know, Mr Devereux, that means live, but there's a slight delay, and I have the facility to pause the broadcast. I can't think that anything is going to be said in this hearing, given the degree of publicity that is already permitted, which will give cause for a pause. Separately, you should know that there are other cameras which are here to record the proceedings for higher quality transmissions should any of the broadcast media wish to use them. They're not live broadcasting. Nothing will be taken from them until after the hearing's concluded, but I don't have a pause mechanism with respect to those matters. I can't think any of that information will be a cause of any problem in the hearing, but I felt I ought to explain that it was the case in addition to the ordinary arrangements.
Thank you very much. My lords and my lady, there is an extra authority which I hope has made it
yes.
into your desk, so to speak.
That's the Portsmouth Hospital Trust against Wyatt.
Yes.
Yeah.
We'll turn to that in due course. My lords, at the outset, I, on behalf of the parents, want to recognise and pay sincere tribute to the experience and obvious humanity of the judgment of Mr Justice Hayden. Anyone that reads that can see and understand that those are features that are within that judgment. We seek, in seeking to deferentially challenge that judgment, to rely on the skeleton argument prepared by Mr Quintavarley, dated the 18th of July.
Yes.
But for the purposes of this appeal, as an adjunct or an addition to that argument, I want to focus, if I may, on some particular points. Those points, I hope not discourteously, I've provided in written form to the court and to the parties. I thought it would be helpful to the court and to the parties to at least have headline points or a route map of sorts, so that the direction of travel is known prior to me standing to my feet.
No, well, I think that's extremely helpful, but as you will understand it is, that it would help me to clarify whether that has any implications for the proposed grounds of appeal, because I note that in the route map, not all the grounds of appeal are topics that are adumbrated.
Yes, and the position is this. We don't seek to withdraw any grounds of appeal,
no.
But our focus and our emphasis is put on the matters that are within the latest document.
Right. So those, as I read your document, some of the points go across a number of the grounds.
Yes.
So you're looking to draw matters together, but rather than make a series of detailed submissions about each ground.
Yes, that's right.
That's not to stop you doing so.
I did embark on an attempt to try and fit in the grounds of appeal with the the new focus, but
No.
there was overlap. And
Inevitably, we will have to approach the proposed appeal, at least in part, through the structure of the proposed grounds, because the permission to appeal is either going to be granted or not on ground 1, ground 2, whatever it might be.
I understand that. By the same token, necessarily and understandably, this matter has come before the court in short order.
Yes, I'm not at all being critical, and indeed I'm extremely impressed by the speed with which your team first and then the other teams have been able to bring this matter before the court. We took the view that it was important to bring this matter to this hearing as swiftly as possible. So nothing I say is to be critical. I just simply want to be clear as to whether you are still relying on all the grounds. If you are, then you are. But
we
if
are.
If you make everybody's task clearer, if you weren't. And so the reply is that you are, so we'll move on.
Thank you. And as the court has been notified, the overall case of the parents is that we say that Mr Justice Hayden's decision was driven almost overwhelmingly, wholly by Archie's medical best interests and not by a careful, clear, understandable and comprehensive evaluation of Archie's best interests in the widest sense. And although you can find within the judgment references to the requirement, or at least a direction, that he is directing himself as to, for example, wider matters or having regard to certain matters, when it comes to the actual evaluation, we say, it doesn't actually happen. So there is, if you like, a trailer that something is going to happen, but when you drill down into the actual equation and see whether he has in fact balanced particular points in favour of continuation of treatment against particular points against, that doesn't happen. And so one misses out the letters between, say, F and Y. One jumps from A to Z. But in particular, we seek to argue, underpinning that overall submission, that the judge failed to give any real or proper weight to Archie's previously expressed wishes and religious beliefs. And that, in fact, replicates or mirrors the position of the Guardian. We'll look at the Guardian's report in respect of that. But both the Guardian and the judge, we respectfully submit, discounted or didn't give appropriate weight to Archie's previously expressed wishes and his religious beliefs. Secondly, we say that the judge failed to give any real or proper weight to Archie's family's wishes and views as to the continuation of life-sustaining treatment. Again, we submit that they are discounted because they derive as part of the grieving process, for example. Third, we submit that the judge failed to carry out a careful, clear, and comprehensive evaluation of the benefits and the burdens of the continuation of life-sustaining treatment. In a case involving life and death, we do submit that there must be a transparent and clearly indicated assessment, indicated for the parents, indicated for in this case Archie, and indicated for the public at wide, assessment and evaluation of the benefits and burdens. One cannot simply say, well, this is an experienced judge, he must have had certain matters in mind, he's done these sorts of cases before, and he's read all the papers. What is required, we suggest, is something far more nuanced, something far more transparent.
Well, I think what you're saying is not nuanced, actually. You're suggesting there should be a list of the burdens and the benefits in a schedule or
Well,
of that-
I'm anxious not to get drawn into the debate about a specific formulaic schedule, fully in the knowledge that you can fall into the trap of that being a map without contours, as your
Yes.
lordship said in a relocation case called Re-F, and indeed Lady Justice King indicated in a case of this nature called Re-A. But that's a different point, I suggest, from the point that I seek to make, which is setting aside whether there is a balance sheet. What is required is, as part of an evaluation, is a clear balancing of benefits and burdens of continuing life-sustaining treatment. And when one looks at the analysis that takes place in this case, I suggest, and it takes place principally at the end of the judgment, that is a deficiency. And
So he doesn't. You've made the point that he mentions a number of the factors that may well be on the side of the equation in favour of maintaining the current treatment regime, but then that's a trailer, and he doesn't deliver those points into the analysis. But you're really, this is partly the same point. You're saying he goes through the judgment, lists all these factors, but in the end, he simply gives the decision.
yes, so you're missing what I think Lord Justice Peter Jackson said in a different context, the engine room,
Yes.
which is evaluation and explanation. And a judge can say, look, I've got to take this into account, or I know the law says this, but he's then got to do it on the facts, the specific facts of the case. And although he says...
At school, certainly, I think it used to be said in maths, you got the right answer, but we want to see your workings.
Yes.
And often I felt short on the workings. But that's the bit you're saying isn't there.
So
the judge lists the evidence that he's had
Yes.
very carefully. It would seem to me listened to both parents and had read the papers in the case and is able to reflect back in what he says about that in the judgment, the fact that he's heard and empathised with
Yes.
what they say, but you say he doesn't bring it into
Yes.
those points into the proper way in the equation.
If you look at the judgment, he starts off with an introduction paragraph. He makes an observation about what the Court of Appeal said. There's then, entirely understandably, a recitation of the medical evidence.
Yes.
There's then the record of what the mother and the father say in their witness statements and their oral evidence.
Yes.
There's then a section on dignity, which he draws from other cases. He then turns to Aintree. He then refers to the Guardian. And then at the end, there are two key paragraphs where he essentially, and those are the engine room, he evaluates and explains. But what he doesn't do, we say, is to evaluate the different factors, the different pointers that would point in the direction of continuing life-sustaining treatment, or indeed those against.
Yeah.
And as to use that analogy, he produces an answer, but what were the workings? And our fourth overall point is that in making that best interest determination, he fell into error in concluding that Archie's life-sustaining treatment was burdensome, futile, compromising his dignity and depriving him of his autonomy. And we're going to come and look at those, particularly at the end of these submissions. I've sought to emphasise in our discussions, my lords and my lady, that in a case of this nature, as in many cases, but particularly of a case of this nature, it is incumbent, as part of the judge's duty, the business of judging, to comprehensively, transparently and carefully fulfil that duty, his or her duty of evaluation and explanation evaluating the evidence, we say, means surveying the whole canvas of relevant evidence and making clear why more or less weight is given to key features of that evidence relied upon by the parties. And although it was provided in a different context, I do seek to draw succour for that observation from the decision of this court, in which two members of this constitution appeared. It's Re B, a child adequacy of reasons, and it's in the authorities bundle at tab 22, page 535. Within that decision, I want to take your lordships to paragraphs 59 and 60, please, which comes within the judgment of Lord Justice Peter Jackson.
Sorry, what?
I'm sorry, it's page 547. I'd like to start at paragraph 57.
Yeah.
And here, some helpful, clear reminders are given. And I accept and acknowledge, as is set out in paragraph 57, that there isn't a pro forma way of giving a judgment. There isn't a particularly prescribed way of doing it right. But a structure is essential, and it's essential for disciplined and transparent decision-making, as is said there. It helps the judge to make the best possible decision and others to understand why the decision has been made. The court's task is not accomplished by handing down a decision that happens to be correct if it's not also properly explained. That's the maths analogy. Fairness to the losing party demands no less. We then move to paragraph 59, and there is identified a number of staging posts along the course of giving a judgment. For the purposes of our analysis of Mr Justice Hayden's judgment, we seek to seize upon, in particular, points 7 and 8. That's to say, the requirement to evaluate the evidence as a whole, making clear why more or less weight is to be given to key features relied on by the parties, and 8, to give the court's decision explaining why one outcome has been selected in preference to other possible outcomes. And as paragraph 60 goes on to say, the last two processes, evaluation and explanation, are the critical elements of any judgment. As the culmination of a process of reasoning, they tend to come at the end, but they are the engine that drives the decision, and as such, they need the most attention, and nowhere more in a case of this nature. Specifically, of a case dealing with best interest, it is the ultimate, we suggest, duty of the judge to focus intensely and comprehensively on the particular child, in this instance, Archie's best interests. And that involves, as this court well knows, an appraisal in the widest sense, taking into account, where appropriate, a wide range of different factors, whether they be ethical, social, emotional, and welfare. And so it's not simply, as this court well knows, an assessment of what medically may be regarded to be the best interests of the particular child. And a useful analysis and summary of the approach, perhaps, is that contained in the Portsmouth Trust and Wyatt case, at paragraph 87 to 89. And the court will be well familiar with this case. These are the intellectual milestones for the judge to follow, as is described at paragraph 87. And that encompasses, we say, the right approach. And at the end of paragraph 87, again, I know that the court will be well familiar with this, it states the court must conduct a balancing exercise in which all the relevant factors are weighed, and a helpful way of undertaking this exercise is to draw up a balance sheet. I don't want to get diverted into the discussion about balance sheets, but I do want to emphasise the requirement to conduct a balancing exercise in which all the relevant factors are weighed. And an example, perhaps, of that taking place is the case of Aintree at first instance. And that, of course, came before Lord Justice Peter Jackson. And if one goes to tab 8 of the authorities bundle, one can see that in that case...
What it would help me, because I'm doing it electronically, what page is it?
140.
Thank you.
We're going to obviously look at Aintree in the Supreme Court in a minute, but as an indicator of the importance of transparently balancing factors within Aintree at first instance, as one can see from the latter end of the decision, counsel is invited to set out the factors. Well, paragraph 79 is how it's articulated. That's at page 155.
Thank you.
And there it's recorded. After discussion with counsel, the following general considerations are agreed as relevant to this decision. In favour of treatment in the event of deterioration, and then there is a list of factors. Against treatment, there is then a list of factors. And that, if you like, is a clear indicator of a judge evaluating and requiring focus on the balancing exercise.
We obviously need to go to Mr Justice Hayden's judgment, but are you saying that a judge needs to actually stick a label on the factors and say this is in favour of continuing treatment or this isn't? With some of the factors, for example, Archie's expressed wishes and feelings, the views of his parents, they are plainly in favour of continuing the treatment. And the question then is weight, and that's a different point. I'm just trying to.
I'm not suggesting
understand what I'm saying is that the judge was in error, because I don't anticipate that you're making a submission that in the course of the whole judgment the judge missed identifying an important factor. What your current submissions are that he identified them, trailer, but he then didn't deal with them.
He didn't deal with them.
Yeah. But he doesn't have to say this one would be pro and that one would not.
Well, that's rather simplistic.
It would never be that.
But he might say something, for example, such as, well, on the one hand, I take into account X, Y, and Z, but that's outweighed by... Yeah. So, for example, the sanctity of life may be outweighed by questions of dignity. Or I've taken into account what is said, and I accept is said about Archie's expressed wishes and feelings, or what the families say, but overwhelmingly I see that the medical evidence points in the other direction. He doesn't get to that stage. He gets to the stage of, well, I know that I've got to think about this. This is what I've got to think about. But he doesn't actually get to the stage of thinking about it. And I pose the question this way, perhaps somewhat rhetorically, but let us assume that Archie hadn't expressed wishes and feelings that were relevant, and let us assume that there were no relevant religious beliefs, what would come out of the judgment if the judge was writing the judgment again on those facts? What would be the particular parts of the judgment that you would have to remove to say, well, it's a different case, and so that's no longer relevant? If you apply that logic and that assessment to the judgment, it's quite difficult in looking at the judgment throughout to work out what it is that would come out. And if that's accepted, then there is a deficiency. And I do invite the court to undertake that process. Let us assume that a particular individual didn't have a religious belief or expressed wishes and feelings. What do I remove from the judgment? I want, having looked at Aintree at first instance, to look at the well-known decision, obviously, of Aintree in the Supreme Court. And I'm going to take this relatively briefly because I appreciate it's well known to this court. It's at tab 10, page 188.
Thank you.
Particular paragraphs I want to take the court to, if I may, are paragraphs I want to take the court to and rely upon, are paragraphs 35.
Yes.
That's obviously reciting the presumption in relation to...
And the judge quoted that in full.
He did, and in fact quoted Lady Black in relation to that. Paragraph 39, which of course is the well-known paragraph. It's a form of discipline,
Yes.
it might be thought.
You're drawing our attention to this, and we obviously know it, but
Yes.
please make any points about it.
Well, the point I make about this is, although the judge refers to it, he doesn't engage with it necessarily very closely or at all. Then paragraph 40.
Had he done so, what do you say he would have collected from reading?
What he would have collected from that is a particular emphasis on the consideration of what the outcome of the treatment for the patient is likely to be, and a weight and emphasis on...
So it's perhaps a bit before, but that's the decision maker, must consider the nature of the medical treatment in question, what it involves, and its prospects of success.
Yes, I accept that he did that.
They must consider what the outcome of that treatment for the patient is likely to be.
Yes.
He did that.
He did that to some extent.
Well, he said there could be no possibility of recovery.
Well, he takes that from the Guardian's report, but that's not in fact what the doctors say in the oral evidence that they gave before.
Well, you would have challenge on the facts.
Yes.
There.
But he takes that from the Guardian's report.
Well, he may quote the Guardian there, but in the course of his summary of the medical evidence, that's entirely at one with that conclusion, and that is his conclusion.
But the consensus of the medical evidence was that there was no realistic prospect of recovery, but the various medics, doctors, indicated that there was outside chances of recovery.
Well, you need to take us to
will.
that, but at the moment I regard what he said about the chances of recovery myself as a finding of fact. And that's important in the context of this paragraph.
Yes.
39.
Yes, I see those points.
Awfully, I mean, everyone must understand that nobody wants to be discussing Archie's condition in these finite terms.
No.
But that's, as I read Mr Justice Hayden's judgment, the finding that he made?
It's, we'll look at it in due course, but it's interesting to note that the Guardian articulates her assessment on the basis of continuation of life-sustaining treatment indefinitely, which I suggest was a material error, but we'll come to that. But returning to paragraph 39, what I say this discipline would have required the judge to do is to focus and give weight to certain aspects that he didn't. So the wishes and beliefs of Archie, the wishes and beliefs of the wider family. Paragraph 40 of...
Before we leave paragraph 39,
yes.
is the gist of your argument that the judge didn't weigh these matters up rather than that he didn't refer to them? Because, I mean, it seems from going through it that we may be on common ground saying that he showed a very acute awareness of all of these matters in the course of the judgment. Your complaint is, as I understand it, not that he failed to refer to them, but that he didn't then weigh them up appropriately.
Yes.
Okay, thank you.
He does refer to them because he recites the evidence and he says Archie's at the centre of my thinking and I've got to take into account his wishes and beliefs. But he doesn't actually do the deed.
Yes.
I mean, if I owe a debt to a particular person, I can say, well, I know I owe a debt to that particular person, but I don't actually, until I've repaid, I'm handed across the cheque, and that's the missing part. Paragraph 40, we say, deals with the rejection by the Supreme Court of the position of Lord Justice Ward in the Court of Appeal as to futility. And essentially, what was taking place in the Court of Appeal was an assessment of futility at a rather high level, whereas the Supreme Court, so far as I read it, were reverting to Lord Justice Peter Jackson's view that there could be treatment that wasn't necessarily futile, but may not necessarily, for the purposes of the law, but not be futile for the purposes of medicine. But we're going to turn to that a little bit later. I want now to just turn to Rakib, the case of Rakib of Mr Justice MacDonald, because I do say that's a helpful, characteristically helpful assessment of relevant factors. It's tab 15, it's page 290.
Okay.
And particularly I want to rely on paragraphs 115 to 117.
Sorry, again, which page is that?
331, paragraph 116, the decision of Rakib.
Thank you.
And there, a comprehensive summary of the relevant matters is set out. And again, some of them will be well known, but they are, in my submission, well articulated there. And of course, reference at subparagraph 7 to the views and opinions of both the doctors and the parents being considered, and that the views of the parents having particular value in circumstances where they know well their own child. He then goes on to say the court must also be mindful the views of the parents may understandably be coloured by emotion or sentiment. It would be unrealistic in a case of this nature to believe that the views would never be uncoloured.
It's human.
And one of the respectful criticisms that I make of this judge is, and indeed the Guardian, is he discounts the views of the family. It appears almost entirely on that basis. And it begs the question.
So that's the, just so we know what we're talking That's the reference to that. Ambushed is the word, is it?
Paragraph 45.
Ambushed by their emotions. Paragraph 45. They've
When it
been
comes
ambushed.
to evaluating the medical evidence, they've been ambushed by their emotions and overwhelmed by an intensity of grief that has compromised their objectivity.
Yes. And
Well, those are quite strong words, aren't they?
they
by
are,
Mr.
and they're
Justice
not.
Hayden.
And I interrupted. I'm sorry.
No, I just was trying to see whether that, compared with Mr. Justice MacDonald in Rakib, however, the court must also be mindful that the views of parents may understandably be coloured by
Yes.
emotional sentiment.
One is putting in context. The other is discounting. And
No, well, Mr Justice Hayden, having seen and heard these parents, is making a finding. He's not discounting them. Saying that for very understandable reasons, this is where they've got to in their ability to face up to or even fully understand the medical evidence. That's not discounting.
But if one looks, and we will look at what the parents said in their position statement, you'll see that it was a far more nuanced position than a simple. And I if I'm permitted to, I diverge from your ladyship's assessment. I do say that he discounts that their wishes and their views there. But we're going to look at that relatively shortly. So Rakib, I say, is a helpful summary. In terms of then the first proposition that deals with the express wishes of Archie and his religious beliefs, we seek to rely on Lambert, which is at tab 32, and particularly paragraph 178.
So in terms of, just so that I know what you're referring to, the first proposition is in your speaking note at
Yes.
page 5, paragraph 5.1.
Yes. And we rely on Lambert,
Absolutely, yeah.
paragraph 178,
Age.
which is page 810.
Different one. Thank you.
855, I'm so sorry.
Thank you. Don't worry. That's got to...
And there, the court is anxious to point out that it's a
I'm
patient.
sorry, Mr. Deverett. The numbering starts again in the second half of the authorities bundle. So 850. So that this bundle starts at 549. You're now going to hear my maths working.
I have 307
307. Thank you.
internal electronic.
I'm so sorry.
Don't worry. So I'm at Lambert.
Lambert, paragraph 178.
Correct. Thank you.
And there we see that any previously expressed wishes, which may have been confided orally to a family member or close friend, are relevant. And that accords, in fact, with the guidelines from the Royal College of Paediatrics and Child Health on withholding and withdrawing life-saving treatment, which are contained within the bundle, the supplementary bundle.
Well, I can't think you need to take us
No.
to that, because that proposition is must be a given.
No, I don't need to. I think that possibly this is dealt with in Rakib as well. We need to.
Well, you'd expect to find it in every case that the wishes and feelings, and any expressed wishes and feelings of the patient, would
Yes.
be part of the decision-making process. Your point is that they didn't get us. They're noted here by the judge, but they're not then taken forward.
Yes. And of course, this is in the context. I don't need to say to this court report of Archie being presently 12 years and 3 or 4 months old. And so when if one goes back to the observations about what he said about life-sustaining treatment, they were provided when he was, I think, 11 on the evidence or thereabouts.
Yeah.
And he went into some detail.
So primary school age still? Age 11?
Yes, but if one uses the analogy with, for example, how much time you want to spend with a parent, or which parent you want to live, or if you're in an international case, do you want to go back to your country of habitual residence? The court would not ignore.
And this isn't, I don't want to raise a factor that wasn't actually raised before the judge, but it's certainly in my mind that I think all the cases that we will go to in these law reports are to do with adults and what wishes and feelings they may have expressed. The top end of the spectrum will be those who seek the right to die, Pretty and others.
Yes.
Adults who for a long time have thought earnestly and carefully about their situation, the options, their family, from an adult perspective.
Yes.
With a child, the Children Act, Section 13A, says that the court must take account of the wishes and feelings of the child, having regard to their age and understanding.
Yes.
Do we have to have in our minds, a filter or an allowance for what we hear Archie was saying when he was aged 11, and have that in mind when we're comparing with what's said in these authorities about adults and the weight to be given to their wishes and feelings?
Not in my submission, because if you go back to Rakib at paragraph 122, that deals obviously with a child and sets out exactly what your lordship is simply saying, that there's a requirement for the court to analyse and to place weight upon
certainly
the child's attitude to treatment. I mean, conceptually, this is very difficult because it's, I'm sorry.
I'm just going to say Rakib is very different because this was a child, as I understand it, who had faced long-term treatment.
Well, I was relying on the principle that's set out at paragraph 122 rather than the facts, but it was, each case is obviously going to be different, but it concerned a child. The conceptual difficulty I was seeking to highlight is that it's all too easy for the judge, and indeed in this case the guardian, to say, well, the particular child, when he or she made observations about life-sustaining treatment, didn't know that they were going to be in an invidious position with all of the situational aspects to it that we don't need to identify individually. And so therefore, we, as the guardian did in this case, and we'll look at it, we don't need to place weight on what the child says.
I don't read anything in the judgment or the guardian's report which says we do not need to place weight on what Archie said. That would be an untenable.
Let me take you then to the guardian's report just to try and make out that submission. The guardian's report is in the supplementary bundle at page 416.
Yes.
What I rely to make out that submission, so that the guardian essentially discounts his advanced expressed wishes in relation to this, is paragraph 65 and paragraph 71. What the guardian says: I've thought carefully about the helpful insight that both parents provide in respect of their son's wishes, but it's difficult to imagine that when that innocent conversation took place between these two close brothers, that Archie at his tender age could ever have thought that such a dreadful incident would or could happen, or that the words he spoke at that time would be relied upon to help form a view of what his views, wishes and feelings are now. So that is a discount. She's saying that second sentence I suggest is, on the interpretation I put forward to the court, is her discounting wholesale what he said in advance. She goes on to say, I also find it difficult to believe that Archie could have any understanding of the dreadful injury that he'd suffered and the impact that that has had on him and what it would mean for him and his future. And she confirms that approach at paragraph 71. I've given great thought, she says, to Archie's wishes as reported by his family, and particularly with regard to his religious beliefs, but for the reasons highlighted above, i.e. paragraph 65, I do not consider that he could have in any way foreseen the circumstances where they are being relied upon now. So what she's saying is these parents are relying on his wishes and feelings, but Archie wouldn't have contemplated the situation that he would have been. Ergo, these parents can't essentially rely on those wishes and feelings. And I say that that's a material error. And it leads to a difficult piece of, well, something difficult conceptually. It places the bar very high because essentially, and to extend it to its furthest extent, it requires, if you like, an individual, whether child or adult, to come to out of their comatose state, to take a look at their invidious and terrible position and then say, well, this is what I think about it, for the court to take that into account. Because in this case, the guardian discounts what Archie says, albeit that Archie says that specifically in the context of life-sustaining treatment. And, I suggest, so does the judge.
So you're saying that the judge can't take into account the circumstances in which the comment was made, or that it was made by a child in those circumstances without the benefit of the life experience that an adult might have had?
No, I'm not suggesting that at all. But what I'm suggesting is that in this case, there isn't. If it plainly will have an impact, but in this case, there isn't any analysis of the circumstances in which Archie made those observations beyond the bald assertion by the guardian, well, he would never have believed that he would be put in this terrible position. I mean, how the guardian gets appointed on the 5th of July, she sees the mother for a period of time, she speaks to the doctors, she speaks to the father on the telephone, and yet she comes to a conclusion that appears to be relied upon by the judge, that Archie would never have foreseen this, and therefore his wishes and feelings and beliefs are discounted. And I just say that that is inappropriate, and it's relied upon by the judge.
So the submission that you made was that both the guardian and the judge, not in terms, but in fact, said we do not need to give weight to Archie's wishes and feelings. So obviously, the focus of our attention has to be the judgment. Can you take us to the parts of the judgment you say that's correct, and where you say the judge relied on the passages in the guardian's report?
Yes.
That you've just taken us to.
It may be a helpful analysis to look at exactly where the engine room of the judgment is. Where is the evaluation on those two key points, propositions 1 and 2, in relation to wishes and feelings of Archie and his advance expressed wishes and feelings, and that of his parents. And also, within the context of that earlier invitation, what comes out of the judgment if this hadn't happened?
Yes.
Just taking your lordships and your ladyship through the judgment, paragraph 1, introduction, paragraph 2, comment on previous decision. Evidence then starts being recited from paragraphs 3. Paragraph 4, the direction, quite rightly, that it's necessary to review the medical evidence and analyse its significance in the context of the overall best interest analysis. So that's a correct direction. He's signposting where he's going. Then paragraphs that follow the medical evidence in some considerable detail. Then we get to the evidence of the parents. Paragraph 24, we have a signpost as to the parents' position versus the guardians and the trust. And then a reminder again at paragraph 25. He repeats it again, entirely rightly. Determining where Archie's best interest lies, not solely a medical issue. It's important that I place him.
So just so that I don't misunderstand, you're going at some speed through the judgment to
Yes.
take us to these particular points. Are you going at a later stage to take us to other parts of the judgment, or is this the moment?
No, I'm dealing with these points.
Right, that's what I thought.
I'm dealing with where is it that the judge evaluates
That's
and
the hope.
places
That's
weight
what I hoped you would do.
on Archie's wishes and beliefs and the family's wishes and beliefs.
Thank you.
Paragraph 25, the right direction. Paragraph 26, this is the judge's pen portrait. Elegant.
When you say the right direction,
Yes.
the judge says determining where Archie's best interests lie is not solely a medical issue. It's important that I place him, his personality, his wishes at the centre of this process. Respect for Archie as a person,
Yes.
etc. So that's where I think if you're saying this was the right direction, the judge describes what will be in the engine room.
Yes.
You say he never delivered
Yes.
on that.
He's saying, this is what I've got to do.
Yes.
And he's right.
Yes.
We then have Archie's a pen portrait, a poignant and appropriate pen portrait of Archie, derived from the statements of the mother, and it appears the mother's oral evidence. That's paragraph 26 and 27. We then have a description of the father's oral evidence at paragraph 28.
Yes.
29 derives from the statement of the mother and Ella Carter. 29 and 30 do. And I acknowledge at the end of paragraph 30 that he says, I'm considering Archie's best interest in the context of a young man who believed in God and whose family believe in God. And I don't want to fall into the trap of seizing on one word there or one word here. But I reflect out loud whether is that a signpost or is that an evaluation? Is context enough? Or should really he be saying, I've taken into account his Christian beliefs and his wider beliefs? The context seems to put it a bit low. And I just make that observation. He then records at paragraph 31,
What do you mean by put it a bit low?
Well, I'm not clear whether that is simply a signpost to the engine room, or whether he's actually placing weight on the fact that this is a young man who believed in God and whose family
If
believed
instead
in
of
God.
using the word context, he said, I'm considering Archie's best interest, he being a young man who believed in God and whose family.
Yes.
So it's right.
I was only asking. This is a 10-line paragraph
Yes.
dealing with the faith of Archie and his family, and I just didn't know what you meant by putting it a bit low.
What I think I put it badly, if I can acknowledge that. What I say is that in the evaluation, in a proper evaluation of best interests, Archie's setting aside his wishes, his advanced wishes, his beliefs were important. Within the judgment, that doesn't seem to sound. That the place that it appears distantly to sound is there. but it's unclear to me by the use of context how it sounds. Is that something that the judge is signposting, that that's something that he's going to have to think about?
Until you latched on, but there's a great danger that we lawyers are going to spend time on one word. But I hadn't read it in the. I can see what I think you're saying, but I read that as the judge saying, "I'm considering Archie's best interests," which is what he says he is doing, and a factor is that this is a young man who believed in God and whose family believe in God. So he is, whether signposting, whatever, he's flagging up that a factor that he is taking into account when I am considering best interest is this aspect.
That is certainly an interpretation open to the court. Then we move to paragraphs 31 and 31, which deals with his views on life support, and he accepts the accuracy of the conversation because it resonates with what Mr Battersbee had said in court. That's to say, Archie's inherent concern about his mother's position. Then we move to a restatement that is concerned with Archie. What he might have wanted is integral to his evaluation of best interests.
So that's not discounting what he wanted, is it?
No, I accept that. I accept that.
Your case is that he discounted it.
Well, my case is that he didn't give real or appropriate weight, and I can discount something without it having negligible weight. Did it have appropriate weight? And what I say is that he didn't, and that particularly is betrayed when it comes to the evaluation at the end.
Could I put a possible position to you when we're considering matters to do with religious belief and the statement that is recorded in that paragraph about turning machines off? I mean, isn't the real point here that Archie is a young boy who had a great joy in life, that he's deeply part of his family, they part of him, and that all speaks strongly, in his case, maybe more so than some others, for the continuation of life, if that can be done. This isn't, it seems to me, really about what Archie may have said on one occasion. It isn't, with all respect, it doesn't seem to me to be a case that turns on the strength or otherwise or existence of a faith. This is really, those are parts of Archie, but really the whole thing is about Archie and his family.
Yes.
And him being as much a part of the family as any lad of his age possibly could be. And that's enough for you.
Well,
I appreciate you want to use every argument that is reasonably available to you, but speaking for myself, that's what the strength of a wish that treatment should be continued comes from, not from bits of evidence which might resound more strongly in other circumstances.
yes.
Now, I've sort of opened that door to at least my thinking about this, so that you can respond.
Well, I wouldn't disagree with that. At the same time, obviously, I need to deploy every reasonable argument that is available to me, and one of which is, unusually it might be thought, here was a young chap who, had, of his own volition, invested time, energy, and thought into the Christian faith.
Exactly, but you don't have to be, at the age of 11 or 12, you don't have to be a Christian to want to stay alive.
No.
The strength of one's will to live doesn't particularly derive from religion, you know.
The difficulty that I have, or I foresee, is that then can be said of any child, and I seek to point out particular features of this case.
Yes, but what I'm querying is a wish to distinguish Archie from, heaven forbid, another child in the same situation, simply on the basis that there was a conversation around the table, or that he believes in God.
Well, I could see that as a position, but
Are you saying that, yes, you agree with what my Lord Justice Peter Jackson is saying, but because of the religious component, it enhances
yes,
the degree to which Archie would wish to hold on to life, were he to have some option of voting, as it were, for one outcome or another. Is that
yes.
it? There's a clumsy word.
And similarly with these observations, albeit that isolated.
We're going back to the word, but that's an additional context
Yes.
around what we all know from what we've read about Archie. What it is part of the context for Archie, which isn't the case for some other children.
Yes.
And for his family, and for his family.
And do you put your cases high as saying, I think you quoted as an expressed future desire to be kept on life support?
Well, that's a rather loyally way of putting it.
But I'm just looking at what Mum said and described it, and this was, as we know, a dinner conversation, if there was a car crash and his big brother said, well, I not want to be continue treated. And Archie says, I won't want to leave my mum.
I would get out of bed for it. He actually goes on to say, doesn't he?
Yes, I would try and get out of bed.
Yes.
Now, is the judge allowed to take that in context, or does the judge have to regard that as a third advance declaration, as you've put it at the beginning?
Well, I don't. That's a little bit. I think I'm not trying to characterise my submission in the latter terms, because I think that is putting it far too high. But the requirement, whether you look by way of the Children Act or whether you look at international obligations as evidenced by Lambert, is to have regard to expressed wishes and feelings on the particular issue.
But you were criticising the Guardians, moving on to her conclusion that Archie, in the context of what Archie actually said, and that limited, very touching actually, dinner table conversation, that the Guardian was wrong then saying, well, how could he possibly know?
Well, how could she possibly know that he wouldn't know? I mean, we just don't. It's a vital part of the engine room, this, and yet it's discounted by the Guardian because she says, how could he possibly know that he is going to be in the invidious position that he's in? But you could say that mutatis mutandis with any patient who almost is in that position. Who knows? And it doesn't. But that's not a blank check to discount the wishes and feelings of the particular patient.
When you use the word discount, you'll be aware that it's a word with at least two meanings. One can mean attach less weight to than one otherwise would, and the other can mean, colloquially, to ignore.
Yes.
I think you're using it in the first sense.
Yes, I am.
No, I thought you were using it in the second. So there we are, the danger of words.
Well, I can't. In relation to.
I thought you were saying she completely ruled it out as.
Well, I've got to be careful because I say that the Guardian completely ruled it out. Yes, but if we're looking at the judgment.
No, I'm talking about with the Guardian. Maybe I was. Trying to be too helpful, but
any help is very welcome.
But could you just be aware when you're talking about discounting something? Could you, in future, as it were, tell us what you're meaning by it? Is it that this is simply recited and then forgotten about?
I think we've had this exchange before in another case, and I've fallen into the same trap. I apologise, and I will be clear in relation to the Guardian. From the passages that we looked at, which is I think paragraph 65 and 71. I hope I've got that right. I do suggest that she discounts the wishes and feelings of, discounts totally at zero the wishes and feelings of Archie. In relation to the judge, what we don't have is, in the engine room of his judgment, a proper evaluation of how they fit into and balance out other factors. And I suggest that I think we were continuing. I don't know whether it was helpful to go through the judgment.
Yes.
And we had got to paragraph 34.
Yeah.
Again, a signpost there. Determining his best interests, I must have regard to the range of Archie's needs and wishes. I must also confront the importance of protecting his dignity. He deals then with some references to previous cases.
So is that the third time he said that I must have regard to Archie's?
Yes. And I acknowledge, again, those signposts are there.
It becomes progressively harder to make the submission that a judge who is writing this judgment as a piece says 3 times, this is what I'm doing, and for us to come to the conclusion that, for permission to appeal purposes, there's a reasonable prospect of persuading the court that he didn't.
I don't accept that at all.
I
don't accept that at all.
Process.
Because just because he says, I've got to do this, it doesn't mean that he actually did it.
Well, it's a short, by the time we get to, and no judgment is written by a judge typing each paragraph and never going back to write. By the time he finishes the judgment, he's read it. But paragraph 34 is towards the end. You say that although he has said 3 times, this is what I'm doing, he nevertheless fails to do it.
Yes. He's signposting it, but he doesn't do it. And it doesn't matter how many times.
So because he doesn't mention it a 4th time, saying this is
it's not
what
a question
I've
of
done.
mention. It's not a question of signposting. It is actually grappling with the particular factor and placing it on in a balancing exercise.
I mean, to a degree, it's what the case was about. The medical evidence was there, and the judge had the medical picture there. The case for the family and for Archie, in the mouth of the family members, is this. It's the wishes and feelings. The family accept the parlous state of Archie's condition. And perhaps I ask you this: what was the choice facing the judge? What was what were the parameters of the decision?
The parameters of the decision were, and this is where the Guardian goes wrong, because she talks about continuation of life-sustaining treatment
indefinitely. That's why I asked, because I picked that up from what you said.
And the choice was a continuation until such time that Archie tragically dies in a natural way, or an immediate, planned, choreographed, whichever way one.
What do you mean by a natural death?
Well, a death that isn't.
Archie is surrounded by more medical infrastructure.
Yes.
Than as much as anybody in the country.
A natural death that is distinct from a planned death, a more natural death, a death that comes at a time.
Essentially, I mean, one could, without wishing to be insensitive about a topic of this sensitivity, one could talk about it as a natural death if one wanted to. One could talk about it as a random death.
Yes. Or one could talk about it as a death chosen by God. But that is whichever nomenclature you use for it, it's not. This is happening on this date.
It's different from a planned event.
Yes. And it's important in this context, and I think this is perhaps the juncture to to emphasise it, to recognise the real benefits that were in favour of continuation of treatment. And these are the sorts of factors that one would expect weight to be given to, as opposed to the burdens. We suggest that those factors would include the preservation, the prolongation of life, the fact that it would be in accordance with Archie's expressed wishes, the fact that it would be in accordance with what I've described, and I take Lord Justice Peter Jackson's point in relation to this, Archie's religious beliefs and values, the fact that it would be in accordance with Archie's family's wishes and beliefs, the fact that Archie does not experience pain, the fact that there is, albeit an outside chance, but the possibility of some recovery, that's on the evidence of some of the doctors, and that the parents' position would allow for, you put it as a random death, I've tried to describe it as a natural death, whichever way that you want to describe it, but a death that is in keeping with the family's values. Now, those are all real, tangible, important aspects of a best interests analysis that require weight.
Are we moving now to, are you still with the reasons challenge, which you've been taking us through the judgment for? Are you now moving to, as it were, the substance?
I'm giving a trailer on substance.
All right.
I'm going to tidy up reasons.
Going back to the choice, and I'm now fixing on a letter from your client's
Yes,
solicitor
on the 10th of July.
on the 10th of July, which I've got in the supplemental bundle at 157,
Yes.
which is not marked without prejudice, and so that's I've flagged that up.
I've missed that. I'm sorry, I didn't hear what you
It's
said.
not marked without prejudice.
No, it's an open letter.
Open letter. I'm not going to read it all, but it says this. So this is from, on behalf of Archie's parents, as all parties now accept, the central issue, this is the second paragraph, in this case is about the timing and manner of Archie's death. Your client's medical evidence is clear that his life expectancy is now measured in weeks rather than months or years. Now that's
Yes.
tragic. But if that's, in terms of the choice the judge had to make, which I asked you about a short time ago, it was to die, use your phraseology, in a natural way in the coming weeks.
With the coming days. I mean,
Days.
let's be clear about it. The plan was within 48 hours of the particular...
No, this is a natural death.
Ah, forgive me.
That
That was
the
the
medical
plan.
evidence is clear, says the solicitors for your clients. Life expectancy is now measured in weeks rather than months or years. So was the choice facing the judge either for Archie to wait
Yes.
and events would take their course in some weeks from the time the judge was hearing it, or to establish a structured and planned occasion whereby the medical support would be removed, the family could be present, and
Yes.
Archie would die in
Yes.
those circumstances.
Yes. And I seek to distinguish that and to rely on the material error of the Guardian. And I'd like to take, in this regard, I'd like to
Well,
take...
distinguishing what?
Well, distinguishing those
So
options...
you're either accepting
No.
my
I'm accepting
drawing of the
your
choice.
characterisation of the choice, and I'm now moving
Right.
to tackle a point that the Guardian
Yeah,
deploys.
and it's right that in that letter, 2 lines further on, the parents' case was on that basis of the choice, as it were. Our clients strongly advocate that Archie's death should be as natural as possible, and the exact timing of his death should be determined only by God. So that's the
Yes.
point. That's the point you make.
Yes.
Thank you.
And can I take your Lordship and your Ladyship to page 432 in the same
So-
bundle?
Sorry, just while there's a second point in this letter, which, as we have it open.
I'm sorry, what's that?
The next page, 158,
Yes.
the second, the
Paragraph.
first full paragraph of whilst they continue to hope and pray for a miracle, our clients acknowledge the medical evidence about the severity of Archie's condition and the clinician's view that he has no realistic prospects of recovery.
Yes, and I acknowledge that, and what I sought to do in our earlier exchange was to identify the difference between no realistic prospects of recovery and no prospect of recovery.
Okay, thank you.
And I identified that that had been taken.
No, that's what I understood. Yeah. Thank you.
And can I then go to the Guardian's report within the same bundle while we're there? It's a particular paragraph I want to go and see, what I want to take your ladyship and your lordships to see is paragraph 48, page 427. Are you there? Please.
So it's got a paragraph 47 on the page.
48.
48.
427.
Yeah.
The two doctors are referred to, and you'll see that they both confirm they see no possibility of Archie's recovery, and I suggest that's probably where the judge extracted what he says in his judgment. But more importantly...
But this is the Guardian's report?
Yes.
It's quite a submission to say that a judge who plainly, he lists over the course of a number of pages the medical evidence, that the judge ignored that and simply lifted.
I don't suggest that he ignored it.
A phrase from as I read the judgment, he analysed the medical evidence and came to his own conclusion.
I don't want to make much of this. It just seemed to me that there was a parallel in language. The better point that I do want to make is that which is at paragraph 72.
Thank you.
Please. There is at paragraph 72, page 432, an appropriate tribute that the mother makes to the nursing staff.
Yes.
And then the Guardian goes on, whilst I consider all those who care for and treat Archie to be doing so with the greatest dignity and respect, I have to consider whether his life being sustained indefinitely in light of the medical evidence would be dignified for Archie and in his best interests. And that, with respect to the Guardian, wasn't the question.
Well, back to semantics. Define indefinitely. Didn't Mum say in her statement what would be wrong for keeping him on life support for another 6 months to see if anything turned up?
Well,
I mean, couldn't that be defined as indefinite? I mean, what's indefinite? Nobody knows.
I think that was the father's evidence as well.
Was it?
But
I mean,
well,
I'm struggling to see how you're saying this was a material error for the Guardian to characterise what the family hoped for, the natural death, which nobody knows when it'll happen, although the parents seemed in that letter to be thinking it might be weeks or months. But it's indefinite because nobody knows. So
well, I take that point, but I was suggesting that one interpretation was regarding that it would be for a very, very significant period of time, which wasn't the question before the court. But I take your ladyship's point.
Mr. Deverett, it seems to me that you make the points you make about the bigger points in the case, the engine room points, and those are the areas we have to
Yes.
concentrate on quite rightly, and you put it very clearly there. I personally think there's a real danger in looking at individual words
Yes.
and saying that means that the Guardian was in error or the judge was in
I might take the hint, my lord.
Well, I think it's not. I just think I think we would be putting too much
Yes.
weight on those matters, whereas the bigger point you make is a much more important one. If the judge has failed to conduct the analysis, as you suggest he has, then the judgment is fundamentally flawed.
Yes, and
Whatever whatever words were used in
yes,
individual parts of the material.
we were then moving through the two cases on dignity, and we got then to paragraph 37. You can take this quite quickly because the judge quotes from Aintree.
Yes, it's
Quite
not
rightly.
not but he quotes the two paragraphs you've already taken.
Yes. Then paragraph 42, he quotes from the Guardian's report. And he relies on the passage that we've analysed about what the Guardian, how the Guardian viewed Archie's wishes as reported by his family. So that features, so perhaps was of some relevance to the judge. He then continues the reference to the Guardian's report at paragraph 44, again looking at the section that we've looked at. And then really the judgment draws matters together at paragraphs 45 and 46. And that's when he comes to that view, when it comes to evaluating the medical evidence, they've been ambushed by their emotions and overwhelmed by an intensity of grief that has compromised their objectivity. So the first point, and again I repeat myself, is within the judgment we submit, there isn't appropriate weight or reference made to Archie's wishes and feelings and beliefs. Second point is that, as one can see, the judge takes a view about the parents, the family's position. And I suggest, with great deference to this judge, that finding or assessment, was beyond that which was open to him. The family knew Archie better than anybody. The position statement of the parents and the letter of the 10th of July had indicated a realism about the position. And the judge doesn't refer to that. And it's...
Was it before the judge, that letter? I noticed that he didn't refer.
Yes, it was.
Yeah, thank you.
But what was before the judge, and I just want to take your ladyship and your lordship to it, was the position statement of the parents, which is in the supplemental bundle at page 127. And that rightly and realistically acknowledged the position. So at page 127, the supplemental bundle.
Yes.
Paragraph 3.
I'm sorry, I missed the reference.
Page 127 in the supplemental bundle.
Thank you.
Paragraph 3. This was before.
Parents hope and pray that Archie will make some sort of recovery and note the medical evidence presented by the doctor.
Yes.
Doesn't exclude the possibility of some recovery. However, for the purposes of responding to the trust's application, they're prepared to accept the medical evidence presented by the clinicians that Archie doesn't feel any pain or discomfort. Any recovery is highly unlikely. Its likely life expectancy will be very limited, may be just a matter of weeks. And in particular, Archie is in a vulnerable condition and may suffer unexpected cardiac arrest at any time.
And that's not referred to, that element of that realistic and appropriately realistic position. So you have the letter of the 10th of July, you have the position statement, and the result though is the judge quite bluntly coming to a view about the parents' position. Of course, And it allows him, therefore, to, on one view, not place it in the balancing exercise.
Well, that's the letter and then this position statement of what the lawyers write on instructions on behalf of the parents. Paragraph 32 of the judgment records what the mother said to the judge. 32, my concerns Archie. Archie's mother described him as her best friend, but for all the reasons considered above, it also strikes me that he also sees himself as her protector, her chevalier. Mum told the Guardian that she knows that Archie would not want to leave her. She told the Guardian that I think he would want me to fight for him for time. I think he would be saying, I'm going to get there. Don't give up on me. That's the fighting spirit. He wouldn't give up. No way.
Yes.
And the judge goes on. So there's a mismatch, maybe understandable, but a mismatch between that position, don't give up, I'm going to get there.
I'm not sure I would accept that that's a mismatch. I don't see those that are positions are mutually exclusive, acknowledging the position as provided by the doctors.
The way in which they are not a mismatch and can be held in the mind together is in the position statement, recovery is highly unlikely.
Yes.
It's likely that the life expectancy is very limited, but likely means there's a chance of something unlikely happening.
Yes.
That he may recover. That's the compatibility between the two.
I submit that there is no mismatch. On the one hand, that there's a realistic assessment by the parents, informed by the doctors, but also an acceptance that Archie has fight, is a particularly strong, always has been vigorous young man, and that he would fight maybe more than most. Where there is a mismatch is between the pieces of evidence that we've identified and the, if I may put it, rather strong, blunt assessment of the parent's position at the end of paragraph 45. Now, the ambush, what informs, where is it that we find the evidence that leads him to that strong assessment that on one interpretation might suggest that he...
Well, you read, do you, I mean, I'm asking for your help, do you read, yes, paragraph 45 as a whole? So what paragraph 45 is about is the reality of the case. The Guardian is required, as I have been, to confront the appalling realities of Archie's situation. Then this, there can be no hope at all of recovery. Finding of fact, I would suggest. Then this, Archie's mum in particular, but the family more generally, recoil from this terrible reality. Nobody criticises them in any way for this. When it comes to evaluating the medical evidence, they've been ambushed. So the conclusion about the emotions overwhelming them to compromise their objectivity, as the judge says, is the fact that they do not accept that there is no hope of recovery. That's how he analyses it. And he's saying that anyone being objective would be driven to the same conclusion that he and the Guardian were driven to. That's his conclusion. We're looking at it. It's not my conclusion at the moment. But he's saying anyone looking at it objectively would come to that conclusion. They don't. They're entitled to. They're his parents. But for them to be in the position they're in, they have been overcome by the emotional
and how does that feed in?
And that's compromised their objectivity.
And how does that feed in, I ask on behalf of the parents, to the requirement for the judge to attribute weight to and take into account the wishes and beliefs of the family?
Well, that's a different point.
But it's a point that I seek to make.
Mr. Devers, I'm purely trying to understand your submission, which is that the judge, in coming to the conclusion he does in paragraph 45 was in some way unjustified in
Yes.
saying what he said on the evidence. And I'm suggesting that if, as he did, he finds there's, quote, no hope at all of recovery, then isn't he entitled to say, I hear, as he clearly did, very plainly what the parents say, but they're not living
He's entitled
with,
to say
with
that.
the reality as I find it to be.
He's entitled on
And that's what
this court's analysis to say that. What I deferentially submit to this court is that he's not entitled to use that as a tool to disregard or to take out of account.
Where are, if there is no hope of recovery, how does he bring back in the parents' hope of recovery when his task is not somehow to balance the parents in the equation? His sole focus is to keep a bright line shining on Archie's best interest.
He's entitled to take into account, looking at the narrow question that he has in front of him in the terms that we've agreed upon, to bring into that question the parents' views, wishes, and to attribute weight to them. And but just because
how do they? How can intellectually, once the judge has decided that there's no hope of recovery, how does the parents' hope for recovery come into the balance? This is an awful case on these findings because the balance is all one way in terms of the hope of recovery.
This is
on his findings.
I don't accept the premise of that, and I do so with great respect to this court, of course, and the members. But there has been there appears to have been an approach in recent years to characterise certain cases as not requiring the balancing exercise to be carried out.
That certainly wasn't what I was suggesting.
Well, then I misinterpreted it.
What I was suggesting is that paragraph 45 shows the balancing exercise, but in this case, the balance is driven by the fact that there's no hope of recovery.
I'm not sure that the balancing exercise can be exemplified by what goes on in paragraph 45. Where is, forgive me if I'm being rhetorical, I don't mean to be, but where is reference to, in the balancing exercise, the preservation of life in the engine room? Where's reference to appropriate weight to his wishes and his beliefs? Where's reference to the fact that he doesn't experience pain? Where's reference to the fact that there is an outside possibility of a form of recovery? Where's reference to the fact that the family wishes, and they know him best,
he found, I'm sorry, this is a very stark finding. There can be no hope at all of recovery.
But that's the wrong question. The question that we're looking at is...
It's not a question, it's a finding.
No, I accept that.
By the judge. And this is the engine room. My question for you is, if that's the finding, if
yes.
The equation is so stark, doesn't that dictate, in the way the judge approached it, his outcome? And doesn't that therefore explain why there isn't a more sophisticated evaluation of wishes and feelings and other matters, because it's simply not possible to go there because of the starkness of the medical evidence?
The judge was faced with the question, do you prefer, does Archie's best interests lead to the adoption of option A, presented by the parents, or option B? There wasn't an option C, which was an ultimate recovery. In identifying what Archie's best interests required, considering the options A and B, there was required of him a balancing of factors that would point in the direction of option A would point in the direction of option B. The fact that a finding has been made that there was no hope at all of recovery doesn't absolve the judge from looking at option A and option B and carrying out that balancing exercise.
I follow that, but you said a couple of times that you were going to take us to some evidence in relation to what you say shows a small possibility of some recovery. Do you want us to know where that is best found?
Can I take your ladyship and your lordship to a number of points in the supplemental bundle? First is at page 171.
170.
100 and just forgive me. But yes, page 171, please.
Thank you.
This is the evidence of the first doctor. The doctors are identified in the transcript of page 162. So the first doctor, and I simply rely on the exchange at the bottom of 171. Are you able to deduce whether with a passage at time he may improve his degree of consciousness? Answer, so certainly from the degree of damage that's present, in my experience it's unusual. That doesn't, of course, plainly mean that there's no possibility, but that's a decision that we made not in isolation, purely on the scans, but in collaboration with clinical progress and clinical status throughout the course of the period of evaluation. At 100
And the discipline of that doctor being?
He was the neuroradiologist, I'm
Thank you.
hopefully reminded. Then uh, 176, please, it's the same doctor. At the bottom, he talks about the chance of recovery is very low in these particular patients, and the outcome is, in my experience, typically that they do not survive, sadly. Again, obviously a possibility that there is a chance of recovery. More.
Sorry, you're saying that means there was a chance of discovery, are you?
Well, an outside
recovery.
chance, yes.
Yes.
Can I take you to page 199, which is the second doctor? This was the paediatric neurologist. And just want to find the passage. It's at the bottom of page 200 and 201. And I just invite the court to read that.
Sorry, I'm starting on 199. You want us to go
So
on
what
to
letter on?
At 200H,
Thank you.
please.
That is the bottom, with nothing at it. So it is Miss Patterson's question.
Yes.
so less than 1%.
I don't seek to do anything but to acknowledge the seriousness of the position. But I do so in the context of the particular question, option A or option B.
But this same doctor on D199 expressed the view. Now, I'm very conscious, of course, that the brain stem test wasn't conducted, but that same doctor does say that they are of the view that he was brain stem dead.
Well, we have to.
But talking about recovery,
Yes.
I'm only praying.
No, no.
I'm only putting that into the equation of the same doctor giving evidence.
I accept that.
And it's, I'm just catching up here, at 201B, which is where the 1% is, the witness says certainly less than 5%, possibly less than 1% chance of recovery from a comatose state, that's Archie now, into some sort of persistent vegetative or minimally conscious state.
I don't seek to do anything but
There's
acknowledge.
a 1%,
It's less,
less than 1% chance of awfully moving slightly up the scale.
That is the assessment of the doctors. I was dealing then with.
Just so I'm clear, at the beginning of your submissions, you said that you were challenging the judge's finding of fact that there was no hope
Well,
of recovery.
I'm not sure where.
I think my lord,
But that was the question that my lord Justice
Yes,
Jackson
and
was asking.
he put me to election.
This is the evidence.
What evidence do you rely upon to indicate that the judge was unfair to?
No, I'm sorry. I think you were asked whether you were challenging that finding of fact, and you said that you were. It was a.
Yes, I think that both of us are.
I think that I think it would be difficult for me before this court to challenge a finding of fact in those circumstances, if that is a finding of fact.
This doesn't give anyone any pleasure that is the finding.
Where are we, Mr. Devereux, in terms of your helpful notes? I'm looking at paragraph 5.
Yes.
You have rightly focused on 1, 2 and 3, it seems to me. And I certainly, for my part, have loud and clear your primary submission, which in fact encompasses all 3 of those.
Yes, and I was
elements.
I think I just want to finish off 3 before going to 4.
Right.
The simple points I make is this: it's a requirement, as for example, Watt and the Portsmouth case indicates, for there to be a proper balancing exercise. As I say, I've tried to not get engaged in a discussion about balance sheets, but it is, in some instances, a helpful discipline. I've tried to indicate to the court that there were benefits, real benefits, in the favour of continuation of treatment for the period of time in question. And I've tried to identify those benefits: the preservation of life in accordance with Archie's express wishes, in accordance with his family's religious beliefs and values.
Family's wishes, beliefs.
Yes. The fact that he doesn't experience pain.
And allows for a random stroke natural, whatever
Yes.
word we use.
And the possibility, within the context of the medical evidence that we've looked at, which I acknowledge, of some limited recovery. And those are factors that weight.
So your submission is that had the judge conducted a proper evaluation, those are factors which should have been on the side of the parents' case.
Yes.
Yes. Good. Thank you. That's very helpful.
Then we move then to proposition 4, and that deals really with part of the engine room at paragraph 46, and particularly the judge's reference to the fact that the treatment is burdensome, futile, compromising his dignity and depriving Archie of his autonomy. The reference to burdensome is potentially inconsistent with at least how the clinical framework suggests these sorts of matters should be approached. And so, for example, in the supplementary bundle, we have the guidance from the Royal College of Paediatrics and Child Health that deals
Reference
with...
to pain, presumably.
Sorry?
You're talking about the reference to pain.
Yes.
But you're not suggesting that the word burden should be limited to how it's utilised in that guidance, are you?
Well, no.
Or are you?
No, I'm not. I'm not. But in simple terms, the traditional interpretation in cases of this nature of burdens is consistent with that is within that guidance. And your ladyship is absolutely right. That requires an element of pain that derives from either the treatment or the underlying condition. In this case, that doesn't apply. So the judge was obviously using burdensome in a different way. But what he doesn't identify is what he was referring to. He uses it to bolster, to consolidate, to underpin a conclusion that the treatment shouldn't continue. But what he doesn't identify is what is it that he finds is burdensome.
Well,
What does he...
I'm sorry, beg
lady.
your pardon. Do finish.
No, I'm so sorry.
But I'm sorry, I'm not following that, because at paragraph 18, he talks about casting light on the reality of Archie's day-to-day experience and sets out the extraordinarily
sets out a
invasive treatments
Yes.
to which Archie's subject day in, day out, 24 hours a
Yes,
day.
he does. But how does that, in my submission, equate to a burden that it's a resource, but it's not a burden that directly affects Archie's best interests?
Why not?
Because he's not aware of that. He's not aware of pain. He's not aware of
Well,
it.
don't we have to think about Baker LJ's judgment? Sorry, is that
sorry.
what you were about to say?
No, please.
Baker LJ's judgment?
In
Yeah.
Fixler.
When
I'm
he
happy
talks
to go
about
to-
physical, you can have physical harm and harm, even though you're unconscious.
Well, we can look at what Lord Justice Baker says. But the first point that I make is you might be right, but there's no indicator from the judge as to what it is that he's referring to as burdensome. I mean, you've identified, obviously, the range of inputs and interventions that he refers to earlier, but he doesn't give us a link.
Well, there is, because he says it's obvious from the detail of the treatment that I've set out above that it, namely the treatment, is intrusive, burdensome and intensive.
Well, it may be that the submission isn't accepted, but I do query the use of burdensome, which falls down against the treatment on the basis that it's inconsistent with the guidance. If that's fine, but if he's using it in a different sense, then we've got to know what sense, because it's obviously being attributed weight in favour of a discontinuance of treatment. And I make the point.
I mean, if one was to read the passage my lady's just read, which refers to treatment that's intrusive, burdensome and intensive, and just for the moment forget burdensome. So say you're right that
Yes.
Archie's not in a condition to be burdened. So it's intrusive and intensive
It is.
treatment. And add to that the apprehensions of those who are giving the treatment that they're doing it to no good purpose
Yes.
and that they find it difficult. Now, don't we end up in the same place ultimately?
Well, I accept if one removes burdensome from it.
So I appreciate if you thought, if the judge meant, as happens in many of these very sad medical treatment situations, that the actual provision of treatment is itself experienced as being painful by the individual patient. That if he'd meant that that was the case here, he'd obviously have said so, but everybody understood it wasn't like that.
Yes.
So I don't understand at the moment the submission that, as it were, the judge was piling something onto one side of the calculation,
Well,
when everybody must have known that that wasn't what he could possibly have meant.
well, I certainly didn't, but perhaps I'm the slowest member of the class. I mean, it's unclear on my reading whether he's simply descriptively referring back to the list of factors that we've seen, or whether this, in fact, is part of his balancing exercise, and that it actually has weight in it in favour of the discontinuance of treatment.
Well, following from what was mentioned before about paragraph 18, that as your clients know better than anybody, the amount of treatment that is being received is incessant. And,
yes.
and inevitably, Archie's existence is conditioned by the fact that he's continuing to receive this treatment every moment.
Yes.
And that, the judge thought, was undignified by now, and deprived him of autonomy, as it were, being more himself than he would be without it. Isn't that what the judge is saying here?
Well, I mean, in terms of the deprivation of autonomy, it wasn't the treatment that was depriving Archie of autonomy, it was the fact that the incident took place in April. So if the judge weighs into account as a factor in favour of discontinuance of treatment the fact that there was a deprivation of autonomy, then that's perhaps, on one view, unfair, because the treatment itself wasn't affecting autonomy. The fact of the brain injury that took place in April affected the autonomy.
Yes.
And similarly, we would...
the autonomy is mentioned in the sentence at the top of the
Yes.
final page of the general. Whereas here, the treatment is futile, it compromises Archie's dignity, deprives him of his autonomy. So it's not that the treatment deprives him of autonomy, it's the fact that it's futile as a result of what took place in April. He has no autonomy.
And
He's in a situation that cannot be resolved by him as a result of the April event, whatever it was, putting him in this position. Sorry, I should have had a shorter sentence, but I hope I've made it plain.
Yes, and I accept that. So the challenge goes to the reliance on the suggestion that the treatment was futile. We suggest that the treatment, on one view, was not futile. Each life has an intrinsic value, point one. Point two, there was a possibility, albeit very remote, that Archie could make some form of recovery. And point three, the treatment allows Archie to pass away in a manner in which he and his family would have wanted. And those 3 points are the response to the conclusion that the treatment was futile. We say that there were points that were in the other direction. Are there any other matters that your ladyship or your lordships wish me to address?
The grounds of appeal, and I certainly don't criticise you at all for taking the course you have, You haven't addressed us at all on any of the specific grounds about the respective articles in the European Convention on Human Rights, the Convention on the Rights of the Child and the Convention on the Rights of Disabled or Persons with Disability.
Yes.
Are you placing any weight on those grounds?
I'm placing weight on the way that they were carefully and effectively deployed in that written argument.
Right. Thank you. Then
I don't seek to rely on ground 6.
No. Got that. Understandable. The test on appeal, do you accept, looking at Airedale, is
Aintree.
Aintree, that's what the name of it. That's paragraph 42.
Can I just get that?
Yeah,
Please.
which is at the top of page 423. Are you there? The very,
I'm at paragraph 42.
and it's the last 5 or 6 lines there. That if the judge has correctly directed himself as to the law, as in my view this judge did, this is in the Aintree case, an appellate court can only interfere with his decision if satisfied that it is wrong, and there's reference to the case of EB, then this, in a case as sensitive and difficult as this, whichever way the judge's decision goes, an appellate court should be very slow to conclude that he was wrong. Now, is that
I have
correct?
to accept that.
Right.
But obviously this court.
Your challenge to the judge's judgment is not that the outcome was wrong, but that he could not have reached a conclusion that's sustainable because he failed to conduct the balancing exercise that should probably
Yes.
have underpinned it.
Yes, and the procedural impropriety point is as effective as the
Yes. No, it is.
the other limb of
That's,
it being
that's
wrong.
the way I understand
But obviously, I have to accept what the Supreme Court says there.
Anything else? Thank you, Mr. Devereux, and those who assist you. And again, is it right that you and your legal team are appearing pro bono?
It is.
Well, we're doubly grateful to you for the time that you have
Thank you.
put into this. I would welcome just a short break, just to take stock of where we are. It's just after 5 to 4. We'll come in not before 4, if that helps people adjust their comfort, but as soon after that as we can.
All right. I just want to remind you all that the live stream will continue ever so shortly.
regard if cookies in the way at any point.
Do you think they might come back and say, we need to hear from you?
They've just gone out.
We haven't made our submissions yet, but I think we're going to take it for sure. 45 minutes. Yeah, yes.
Yeah.
Very careful.
Yeah.
Examination. And that's the actually determined.
Yeah.
Mark, thank you for this.
Oh, yeah.
Sorry, my dog was not standing on the exam results.
Yeah, no, that's fine.
This grants them the earliest summary is quite useful, I think.
Court rise.
Mr. Miller, it occurs to us, and this is no criticism at all of the parents and their team, that the case as it's now put on appeal is wholly different from that which was cast in the skeleton argument and the grounds. I don't think the case that's been advanced this afternoon is actually referred to in the skeleton or the grounds in the way that it has been. Plainly, now at nearly 4:10, this is a permission to appeal hearing with the appeal to follow, so we expect counsel to make their full submissions as if it was a full appeal. We're not going to finish this afternoon, and so what we have in mind is, rather than you and the Guardian's team either making very short submissions, which would not be helpful to us, or having to develop your submissions without the chance at least to discuss the cases that's now being put before the parents, that we ought to adjourn now at this stage in the progress of the proceedings and sit tomorrow morning to conclude the hearing. I don't know if that's inconvenient to anyone who needs to be here. As it happens, the court is available, so from our point of view, it's possible to rearrange matters to be here.
Yes, I'm available, and I'm grateful for the opportunity to gather some thoughts. It will probably make things more efficient.
But that's often the way.
In the longer run. Obviously, I could make very, very short submissions, but I'm not sure they'd have any value.
No,
probably
it's
so short.
Mr. Devereux has clearly been able to expand his case properly as he has, and it needs to be met properly.
Yes, and he has reserved all the points, all the grounds of appeal.
Yes, bar one.
Bar one.
Which wouldn't have taken time. So unless anybody, and now's the moment for anyone to say there's a difficulty, has a difficulty, we'll sit at 10:30 tomorrow morning on the expectation that it won't last beyond the morning. I'm not tying you down, but that would seem to me to be the schedule. Is that acceptable?
Well, of course. The only I might have to get one of the clerks to the court just to help me with a High Court judge who might be less impressed than otherwise.
Right. Well, if there's any difficulty,
but I certainly will
let my clerk know, and this clearly takes precedence.
Yes, of course.
Taken this case into the list because it's necessary to do it at very short notice, and that's what has to happen.
My Lord, I too can be available tomorrow morning, and I'm grateful for the opportunity to gather my thoughts.
Good. Right. Well, we'll sit. Assume it's this courtroom again at 10:30 tomorrow morning. Thank you.
All rise.